The Teacher Liability Protection Act. This is for EDL 850 School Law by Mark Penka. A little history behind the act. The act was originally proposed by Paul D. Cordell, and it didn't come into effect until January 8, 2002, when George W. Bush signed it into effect. And then it actually comes into effect on April 8th. And this is not only for teachers, but for anybody that works in the school, school board members, office personnel, and even possibly custodians, bus drivers, anybody that works for the school district. And this applies to any school where they're receiving Title I funds, which is most schools, almost all public schools. What this act limits the liability of school officers and employees for acts of omission on behalf of the school if, one, the teacher is just doing what they're hired to do. I mean, it's basically what that is. Secondly, if the teacher didn't break any laws in what they were doing, whether it be state, federal, or local laws, and if they even properly expel or suspend a student to control the classroom. Next is if it's a licensed teacher. If the teacher has a license and is properly certified and so forth, that helps as well. Fourth, if it's an accident or non-intentional. People are going to make mistakes. As long as it's not a conscious mistake, one where you're actually lose your temper and are trying to hurt somebody, whether it be through grades or physically hurt somebody. And last, as long as no vehicles are being used. And this even extends clear to airplanes. Acts committed that do not apply if it's a crime of violence. If you hurt somebody willingly is what it's saying. Next is if it involves a sexual offense. Anything involved with the sexual offense does not apply to this. If it involves misconduct for where it breaks their civil rights. If you go against the civil rights, then it will not apply. And lastly, if you've been drinking or if you're under the influence of any illegal drug or narcotic. And this was just a slide to show the first one. It's kind of an extreme case, but the four elements that must occur for there to be considered yes. The teacher must have a duty to protect students from unreasonable risks. That's just kind of self-explanatory. Don't send them into an area or have them on a field trip or something, or just make sure you're doing your job and you're taking the precautions that are needed. The teacher must have failed in the duty by not exercising a reasonable standard of care. Once again, as long as you're paying attention and doing what you're supposed to be doing, whether this be in a science lab or in a shop or, like I previously stated, on a field trip, then you'll be fine. Third, if you're just not properly caring for the student and somebody gets injured. And then lastly, if you have been drinking or under the influence. If nobody actually, that was the wrong notes. If nobody actually gets hurt, if there's no mental or physical damage, then negligence cannot occur. And this was just a slide to show, a courtroom decision. How it will help teachers and administration. This takes away any liability, any action regarding the control of your grades. If you suspend a student, expel them, or just any discipline with the students. Students, if they're doing something wrong, then it gives you the control to do your job to make sure that it's a learning classroom. If the student's if they've been drinking or under some substance, in the possession of a firearm, obviously, if they have alcohol present, and so forth. And lastly, if they decide to sue you and they really have no reason to stand on if the teacher was acting in accordance to what they're supposed to be doing by laws and by just doing their job, that if they wrongfully sue you, then you'll be awarded up to $2,000. This would just be kind of to stop students from illegally just trying to sue a teacher or somebody that works in the building. And it'll also cover the attorney's fee.